Speed, okay. So I did send you the links already for your monitoring session today. Those that were monitored. That's amazing. I mean, you were monitored and in 15 minutes you got the link. Really cool. And that we can do that actually maybe from now on during the break. So then I use the break to send those links, and therefore you have it right away. Because it's nice to have that, as soon as possible, right? So you can see how you're doing and all that stuff. Particularly if we divide the practice before the break and after the break. So then when you implement after the break, after watching the link during the break, then after the break you kind of implement some of the things that I suggested. All right, so now what we're going to do is we're going to talk a little bit about civil, and this is going to be an interesting thing. You have to first remember that most of the terminology that you have been studying is in the criminal jurisdiction. In fact, all the terminology is in the criminal jurisdiction. But there is a second jurisdiction, and one of the things which is civil, of course, one of the things is that when you become a court interpreter, you're a court-certified interpreter. It doesn't say criminal court, or it doesn't say civil. So court-certified interpreter serves both jurisdictions. In fact, in the County of Los Angeles, interpreters that are certified working in the criminal courts also work in the civil courts. So the county provides civil interpreters, and those interpreters are actually the same ones that have been trained to pass the criminal exam. So they may or may not have knowledge of civil terminology. So it's always a good idea to have some knowledge of it, although what we cover here is going to be kind of on the surface, doesn't get too deep into it. So you may still need to train yourself if you are assigned to civil matters. But the reason why we can't go too deep into each area is because it will take 6 months to go over it. The state exam wants to reflect that civil is being tested in the exam, and they always tend to do that by adding just a few words here and there. So it's just more like a protocol than anything else. It really isn't. It doesn't really test you on civil matters. So if one keeps that in mind, all we need to do is just learn some basic stuff in terms of civil jurisdiction, and that we should be okay. So let's get into it. The first thing that we have to be careful is that the two parties that are involved in the criminal jurisdiction are also in the civil jurisdiction. So here is criminal, here is civil. We know that in criminal, defendant is acusado, and we know that in criminal, plaintiff is parte querellante, if you remember that, or parte acusadora. However, in civil, plaintiff is parte demandante, and defendant is parte demandada. Can I just remove parte? Yes, but if you remove parte, you're going to have to say el demandante o la demandante, and you have to assign a gender to that plaintiff. And sometimes we don't know because it's on paper, or we just hear, we don't know if it's a male or female. And the same thing is true for demandado o demandada, if we remove parte. So in a side translation, if you know that it's male, then you can use, let's say if you know the defendant is male, then you can use demandado. If you know that the plaintiff is female, you can say la demandante. It's perfectly fine. See, although in English, these two terms really correspond to civil and to criminal, right? As you can see here, but it's the same term. So sometimes they use in English criminal defendant. And we don't have to translate criminal defendant. For us, that we already know that it is acusado. We don't have to say acusado en la jurisdicción penal. It doesn't make any sense. Because when we say acusado in Spanish, we know it's in the criminal jurisdiction. The reason why they add criminal here is because for them, defendant could be in civil or criminal. And the same thing is to say civil defendant. But when they see civil defendant, for us, it's just parte demandada. Because when we say parte demandada, we know that we are in civil. But they have to add civil right before defendant, because defendant is for both jurisdictions in English. And the same thing happens with plaintiff. Just want to point that out because sometimes you may see a criminal defendant and you may say, well, I have to transfer criminal, but you really don't. When you say acusado, that's okay in Spanish. You don't need to say anything else. To say acusado en la jurisdicción penal is completely redundant and completely useless. Or if to say parte demandada en la jurisdicción civil for civil defendant is the same problem. You don't want to do that because it's just redundant. So in most site translations, they are not going to use the criminal or civil. They're just going to use defendant or plaintiff. So one of the things that you want to do when you're looking at a site reading, so you want to, if you see the word defendant, you want to confirm whether it's criminal or civil. And the same thing for plaintiff. And you will know whether it's civil or criminal because if it talks about punishment, jail and things like that, it's criminal. If it talks about probation, it's criminal. But if it talks about amounts of money and lawsuits, then it most likely will be, or civil actions, then it most likely will be civil. So sometimes what they do is they give you a site translation that has 2 paragraphs, and they talk about a person where in paragraph number 1 was actually 3 years ago a civil defendant, and they use the word defendant. But when you read it, you realize that it's civil. And then in the second paragraph, they talk about the same person that he has a case in criminal court, which in that case, criminal will be, defendant will be acusado, right? So you gotta make sure that you can figure out in what jurisdiction that term is used, under what jurisdiction, and that's really critical. So that's something to keep in mind. Now, within civil matters, you have different type of proceedings. You have, for example, family law. So you could have, for example, proceedings under family law. You have proceedings that have to do with probate. You have proceedings that have to do with contracts. And you have many more, but these are the 3 key ones for your state exam, okay? You also have personal injuries. You have malpractice. You have small claims. There are many different other ones. We're going to concentrate mainly on these 3, and look into how to use these terms correctly. Within probate, we should be aware of the fact that it has 2 different areas. One has to do with a disease. Another has to be with a minor or an adult. An adult incapable of managing his or her life. By that I mean cannot make the right decisions, such as for his or her care, medical care, for how to use money, his finances or her finances and all that stuff. In the case of a deceased, un difunto, that has to do a lot with last will and testaments. In Spanish you can say, this really, most of the dictionaries will transfer this as última voluntad y testamento. Spanish usually is just testamentaria, or testamento, that's it. And that basically talks about somebody who has money and leaves the money to family members, and then that person before dying prepared this document and give instructions as to what to do with his or her money, with his or her house, car, assets, dogs, cats, whatever that person has, possessions that he has on earth, and what to do with them, to distribute it to another person, to sell it, to give it to charity. I don't know, there are many different possibilities. And then the minor part of it, for minor or adult, minors, it deals basically with emancipation, which in turn requires a custodian. Emancipación, custodian es tutor. So it means that somebody who's 16 doesn't want to be under the jurisdiction of his or her parents, so wants to emancipate, goes to court, explains to the court why, and has to propose somebody who will be his or her custodian. Because if he's 16, he doesn't have the legal ability to make decisions on his own. Whatever decision he makes, it's not valid under the eyes of the law. So needs to have someone who will take care of that person and make the appropriate decisions, such as if he gets sick, whether to get blood transfusion, for example, or not, or if he gets sick, to what hospital to go, or if he goes to school, to what school to go. There are many different things that are more of legal in nature that are actually taken care of by adults, okay? The minor cannot make that determination, obviously. If it is an adult incapable, and then there is also, if it's an adult incapable of managing, we're talking about conservatorship. Conservatorship. In Spanish we call that curatela. And a conservator, que es un curador, a conservator or a conservatorship is usually assigned to people who are of legal age and may have some mental impairment, such as Alzheimer's or dementia. And one of the things that a conservator does is will make the decisions for the individual. In other words, if the person lives in a house, has dementia, nobody else is around, and or the court appoints that conservator to take care of that person, that conservator can actually sell the property, put the adult in any care that he thinks is appropriate or she thinks appropriate, can really take advantage of the elderly. Of course, if the person wants to commit fraud, and there are many instances of that happening. The courts are very flexible with people like that, with conservators. There seems to be like an industry behind all this, and it is pretty scary thing, honestly. So that's a possibility. Now, of course, all that can be eliminated if you have a power of attorney, giving the power to maybe your daughter, your son, or whoever is around to take care of you, right? And that power of attorney takes care about, it's like you are now becoming the conservator. But the key is that person who is of a certain age has to appoint that representative, has to give the daughter or son that power of attorney before he or she is declared to be legally incompetent. So you can see the problem here. If you have a conservator who is in agreement with the doctor and the court is very flexible, then you can have a conservator looking for people that have this type of issues now, and the doctor approving, indicating that yes, this person now has a mental condition that prevents that person from doing any type of decision-making process. And then it could become a really huge scam. And there has been many cases here in Los Angeles. And so it's one of those areas of the law that it's very, very hard, because it really needs to be revised, in my view. But for us, we're not going to worry about that. We're going to worry only about terms. So when it comes to probate, that's what we deal with. So for family law, it's when we also have some divisions in family law. Within family law, what we do, which is family law, is derecho en lo familiar. Family law, we have two possibilities. The first one is the typical dissolution of marriage. Which is divorcio in Spanish. No es disolución del matrimonio, es divorcio, that's it. In English, some of you may say, well, can I use divorce in English? See, in some jurisdictions, divorce can only be used when it has been granted by the court, but not during the application process, during the petition process. The result of that dissolution of marriage may have some other things. If the couple has kids, see, everything, if you have assets, you can split them, but you can't split the kids. So if you have children of the matrimony that are not of legal age, clearly, then those individuals there is also now issues that have to do with legal and physical custody of those children. And legal custody in Spanish is tutela, and physical custody is generally custodia física. In other countries in South America, they use other terms for this. They use the word tenencia del menor o de los menores. So both of them are used, but mainly this is the one you're going to see the most because this is the term used in Central America and Mexico. So if you get divorced and you have kids, then you're going to have more issues. And then after this, this continues if you have kids, then you have visitation rights, and which is derecho de visita. And then you also have, believe it or not, things such as child support, manutención al menor. In the case of the dissolution of marriage, here you may have spousal support, which has a very unique term. It's pensión alimenticia conyugal. Pensión alimenticia conyugal. You can see how all these terms kind of fall into different jurisdictions, right? So if a couple wants to get divorced and they don't have children, they will stop at the dissolution of marriage, and the only issue that can be dissolved is, besides the partition of the properties or assets, which assets, by the way, is bienes, assets. Besides the partition of assets, is going to be the issue of spousal support. And that's the end of it, really. There's once they decide on who's going to keep what, and all that, you will, and the spousal support, then that's the end of it. But if you have children, it becomes way more complicated, way more complicated. The question is, how do you say probate? Probate, and it's a very tricky question. You have probate, court, Tribunal de Testamentaría, so probate as a noun is testamentaría, but they also use it as a verb, to probate, which is usually to probate a will. Oops, give me a second. And in this case is validar un testamento. So, probate has different translations. It could basically be testamentaria if it's a noun, or it could be validar if it is used as a verb. And that's, so we look at family law as well. Now let's look at contracts. When you talk about contracts, there are different types of contracts. You have real estate, contracts that deal with real estate, bienes raíces. Then you can have contracts that deal with labor law, derecho laboral. Or you can have contracts that has to do with agreements between parties. And by that I mean anything. I can get into a contract. I mean, when you sign up for a course here, you enter into a contract with us. So we provided a certain number of hours of instruction, right? And you pay a certain amount of money for those hours. If you don't pay, you cannot attend. If we don't provide the number of hours of instructions, then you have a claim. You can come and claim and say, no, it's supposed to be 12 hours and you provided me only 10. I need the other 2, and we have to provide that to you. Either on video or live, it doesn't matter, but we have to provide the instructions. You could have an agreement with your neighbor saying, you know what, if you turn off the TV at 10 a.m., I won't turn on the radio at 8 a.m. That's an agreement. That's a contract. Clearly, it doesn't involve money in this last case, but in most cases, contracts do involve an exchange of money. And if they don't involve money, that becomes way deeper into other area. We're not going to talk about that. But the ones we really want to talk about is the contracts where you actually, there is an exchange of a service for money or a thing for money or whatever the case is. And whenever money is involved in a contract, that party, the contract is looked at from the point of view of the one who pays the money. So, and the reason why I'm saying this is because, just to give you a typical example, you go to, let's say, Mexico City, you're on the streets and you look up and suddenly it says, se renta. And you may say, wait a minute, I thought that doesn't make any sense, right? Because se renta no tiene sentido, porque to rent es alquilar, no rentar. Is there a difference? The answer is certainly. When we say se renta, if it was placed by the person who offers the property, then it's a correct sign, because for the one who owns the property, you want to put it in the market to get una renta, which means an income. But when the person who actually goes and rents that place, who's paying for it, it doesn't get un income. On the contrary, you pay the income, right? No es un ingreso, no es una renta. Simplemente está pagándole a la otra persona la renta. So what does the person who pays for the rent benefit from? Well, it's to have possession of that property for a period of time, and that's called alquilar. So that's why, from the point of view of the one who pays the money, so the question is, how do you translate rent? Is it a renta o alquiler? Well, you may say, well, if it is coming from the owner, it's renta, but if it's coming from the one paying the money, it's alquiler. But I just said that in any contract, every contract is looked at from the point of view of the one who pays the money. And in which case, every time we see the word rent, must be alquiler, no renta. That's the difference. But it doesn't mean that it's incorrect to see se renta. Or somebody tells you, voy a rentar mi propiedad, the assumption is that he's the owner. But if I say voy a alquilar una propiedad, the assumption is that I'm going to pay for that property, for that rent. So when money is involved, that the contracts are looked from that point of view, and the money itself is known as a consideration in the contract, which we say in Spanish, contraprestación. And it makes sense if you look at it, because una prestación puede ser, por ejemplo, una prestación de servicio. So I hire an interpreter. I want the interpreter to interpret in court for 4 hours. Esa es la prestación, the service rendered. And I'm going to pay the interpreter $300. So that's going to be the consideration. That's the money, that exchange of money, service for money. Well, in Spanish es la contraprestación, es lo opuesto a la prestación, la contraprestación, lo que compensa a la prestación. And that's why we use for consideration contraprestación. You could also use causa contractual, but that's used when there is no money. And when there is no money? Well, the example I just gave you, you turn the TV off, you turn your TV at 10 p.m. and I don't turn my radio at 8 a.m. Is there a money exchange? No. So if I see the word consideration in a situation like this, I wouldn't transfer it as contraprestación because there is no prestación. There's no money. So I will transfer that as causa contractual or motivo contractual. Now, if money is involved in this transaction, it will always be consideration, will always be contraprestación. Okay? So this one is particularly important for us, for state exam purposes, because they love to put civil terms associated with the rental of something. So when we talk about real estate, the first thing we want to remember, when you talk about contracts in real estate, the name is really agreement. So you're gonna, if you go and rent a property, it doesn't say contract. It's gonna say rental agreement, for example. If you go and buy something that is a property, it's gonna be agreement all the time. But for us, so in this case, cannot be acuerdo. So when you use the word agreement in context of being a contract, like a rental agreement, it cannot be acuerdo de alquiler. It has to be also, for us in Spanish, it's always contrato. So for example, a rental agreement es un contrato de alquiler. A lease agreement es un contrato de arrendamiento. So you basically have to be careful with the word agreement now when dealing with contract law, because it doesn't mean what we think it means, which is actually acuerdo. What it means in a contract law, the word agreement, is most likely going to be contrato. You're going to be careful with that. So those are the three basic things that we need to work on: family law, probate, and contracts. Now, okay, what we're going to do is we're going to start with contracts, okay? Which family law we are not going to be able to start now. So let's talk a little bit about the contract. A contract has two parties: the offeror and the offeree. El oferente, that's the one who puts the property for lease or for rent. Y el receptor de la oferta. Because a contract, if you ever study economics and stuff like that, this is all about what's a fair price. What's the definition of un precio justo? It's whatever is agreed between two parties. That's why sometimes you have, works of art that are $80 million. Is that a fair price? Yeah, it's a fair price. Because if both parties agree, then one is in agreement where the amount is sufficient for that work of art, and the other feels that, yeah, I can pay that because I think it's worth it. That's why when a house is sold close to your house and it's sold for a higher value, then the value of the square footage of your house increases. If you bought your house for $500,000 and now the properties around you are being sold for $1 million, then your house is worth it. The square footage increased double. Because nobody can say what's the right and what's wrong price, right? Look at the gas, for example, now. Why is it so high? It's high because, first of all, we don't have much saying in agreeing with the price anyway, but it has to do with the offer and the demand of it. If there is not enough, then there is going to be more expensive. And that's just basic economics. That's the way it works. So nobody can set a price. You cannot come, for example, and say, oh, you're charging too much for this. Well, if you don't like it, don't take it. But there will be somebody who finds that it is reasonable. So it's just the way it works. And the offeror is the one who puts something as an offer, offers something to the market. And the offeree is the one who receives that offer and in exchange pays for it. So you can say that the offeree is the one who pays that consideration, esa contraprestación, and the offeror is the one who's going to give you the asset, el bien, or maybe the service, el servicio. It's going to render services, el servicio prestado. When these two get into an agreement, we say that they enter into an agreement.